Okay. All right, welcome everyone to Trial Ad. On behalf of Professor Cialino and myself, we're very happy to have you here for what is the first time that we are teaching this class in this particular format. Usually it's a small group of about 12 students. And while the methodology is going to be essentially the same, because of the size of the class and the use of adjuncts, which I'm going to talk about in a minute, it's going to require a little bit more logistical planning and organization. But you are going to benefit from having not only Professor Cialino and I give you lectures throughout the course, but perhaps even more importantly, some very esteemed adjuncts consisting of lawyers and judges and very good trial attorneys who are going to be taking you through the paces each week as you do the weekly performances. So in addition to that, we have 2 teaching assistants that are resources for you, Shanice Smith-Banks and Delaney Shea. And you will see them throughout the course. They will be in the weekly performance sessions, and they are there for you. If you have any questions about anything or need anything, they stand ready to assist you. So what we're going to do this evening is I'm going to talk briefly about the course, give you a course overview, the objectives, the expectations for the course, the class methodology, and then Professor Cialino is going to lecture you on public speaking and advocacy and rhetoric. And then after that, the adjuncts are going to come up here into the room and introduce themselves to you so you'll get an idea of who they are and what their backgrounds are. So the things I want to talk about today are, first of all, course description and the objective of the course. The overall objective of the course is to develop fundamental trial advocacy skills through simulated exercises. That is the main teaching device. In other words, you learn by doing. That's going to be supplemented by lectures, how-to lectures between Professor Cialino and I. But the main learning mechanism is for you to get up here each week and perform the designated exercise with the critique of these adjuncts. And there will be 2 adjuncts in each of your small group sessions. You all will be divided into small groups of approximately 8 to 10 students, and there will be 2 adjuncts in the room working with you as you perform these exercises. So we're going to cover the major components of the trial, not everything because there's a limit to what we can cover, but we're going to cover opening statements and directing cross-examination and introducing exhibits and using demonstrative exhibits and closing arguments. So by the end of the course, the objective is to, hopefully you will have progressed to the point where you will be able to try any case against any opponent in any tribunal. Now that's a heavy task, but I think you will see the progression in yourselves and in your colleagues throughout the course. So we want to instill these core competencies so that you're able to try a case the very first time out. The course material that we're going to use consists of 2 main things. The how-to manual. When I say how-to, this is a instruction manual on the major components of the trial that I've just mentioned, and they tell you, or I should say suggest to you, ways of doing things. Nothing is in black and white and one stop, one way of doing things. You will find that this is merely a suggested approach. And in some instances, the approaches suggested may actually differ with some of the weekly instruction you'll get from the judges and attorneys, and as well as Professor Cialino and myself. I'm going to talk to you a little bit more about that sort of, inconsistency in suggested approaches. But it's inherent to the process because the process of trying a case is more of an art than it is a science, and there's more than one way to do any given task. Okay, so LeBay is your how-to book that you're going to consult each week. So if we're working on direct examinations for the performance that week, you read the chapter on direct examination. And we're not going to assign sections of the book. You should just go to the sections to get a feel for how you should structure your particular exercise for the week. So that's the how-to book. The case file that we're going to be using is Fulbright versus Americraft Industries and Parker. It's about a 100-page case file, but there's a lot of information there. So you need to start day one familiarizing yourself with the case, as if these are the clients that you're going to be representing, whether you're assigned to the plaintiff or defendant's role, which roles we will give you later on. But you need to become familiar with the facts of the case and start representing or thinking about representing these folks from day one. Remember, in about 2 weeks, you're going to be giving opening statements on this file. So you need to start getting ready for that in the sense of familiarizing yourself with the file. Once you get your designated role as plaintiff or defendant, and we need to make sure we give them that assignment relatively early so that they can start viewing this from that perspective. But it really doesn't matter at the outset in terms of your preparation and familiarity with the case file overall. All right? So all the weekly exercises are going to be based on the Americraft case file, as well as the final trial that you're going to do at the end of the course. Each of you are going to do a final full trial. Okay? All right. The method of the instruction I've alluded to somewhat already. On Mondays, you're going to be working with 2 adjuncts in groups of 8 to 10, right, on the given exercise for that week. So class on Mondays is a little bit longer than on Wednesdays. It's 5:35 to 7:15 to give you more time to actually work through the exercises. Because trying a case is a skill-intensive endeavor. The only way to learn is by doing it, and the more you can practice, the better you will get. So we want you to get as many turns at bat as possible. So that's why the difference in the times for the classes. We hope to, and I think we will, have in place a method for you all to tape yourself with your cell phones. We're working on getting tripods to have available in each room. So before you get up to do your direct or cross-examination, you situate your phone in a tripod, record it, and then use that for self-evaluation later. You'll be amazed at what you see, the things that you're doing. Everything from little subconscious movements or tics or just nuances of the way you're speaking, the cadence, the rhythm. It's just a wealth of information just from the visual impact and effect of your attempt to persuade through these exercises. All right, so that's an invaluable tool. I'd love to be able to have the luxury of us going over it in video, or going over the video with you, but just pragmatically that's not possible. So do take advantage of that. Now, you need to be prepared from week to week to play the role of the attorney and the witness. Okay? Preparation is essential in this course. It's not a some tiny kind of thing. Everything depends on preparation. Nothing works without it. So you're going to have these judges and attorneys and DAs who are coming down here every day or every week to help you. It's not going to go over well if you're serving the role of a witness and you don't even know the fundamental facts regarding that witness's testimony. Now, if you're doing, for example, a direct examination of a witness, it's an inextricable requirement to know what the facts are from that witness's perspective. So it's not like you're doing double work. It's just that keep in mind with your preparation, you need to be prepared to be called as a witness and as an attorney. And there's enough time and the groups are small enough so that each of you should have a turn for every exercise. It may not always work out that way, but it should. And each of you should, in that given week's exercise, play the role of the witness. Now, Preparation, it's not just a phrase. It's what wins cases. And trying cases requires a lot of hard work, a lot of preparation. And the unprepared attorney is going to be the unsuccessful litigant. So it's a good, sort of practice now to be ready. And I mean be ready in every sense, because you want that exercise to benefit the attorney who's playing, or your colleague who's playing the role of the attorney, right? If the first question he asks you is, state your name for the record, and you don't know your name as the witness, that's a bad start, right? And you can imagine more substantive facts if you're completely unaware, or you have to look at a sheet, or you have to, I don't quite recall, nothing is going to work in terms of getting the most out of that exercise for the benefit of your colleague. So think about, you're wanting your witness to be prepared when you get up there. Well, think also about your colleague having the same desire and need. So I just ask you to, really, really be prepared. Now, a trial is really a battle of competing narratives, right? You have the same facts, immutable facts, right? And you have two different ways of looking at those facts. So it's important for you to be the truth giver in that process. The trier of fact, whether it's a judge or a jury, is going to be looking to who is the truth giver, right? Critical to that process is projecting authenticity, okay? If you come across with affected behavior that's outside the boundaries of your personality, it's not you, it's not going to be persuasive, it's not going to be authentic. And persuasiveness and authenticity go hand in hand. So what we're going to do, or try to do, is to help you to develop your litigation, or I should say your trial advocate persona, working within the boundaries of your personality. Now, you're going to see through your colleagues and maybe other attorneys that you witness in practice at trial, you may say, boy, that guy or woman, they were really effective. Maybe they had a rat-a-tat-tat machine gun style, but that fits their personality. Maybe they're type A personality, right? But you're not. Maybe you're a more folksy sort of personality. You like to tell stories, and you like to tell it in maybe a less rigid manner than someone who's, firing on all cylinders at all times. Or maybe you're a more cerebral litigant, right? And you quietly, but effectively, dismantle the other side. My point is that these different styles, they can be equally lethal in terms of your objective, which is to win the case. So try to find a style with which you are comfortable in your own skin, because that's going to make it more authentic, and ultimately it's going to make it more persuasive. Okay? So it's going to take, you're going to have to experiment with that a little bit, and that's the good thing about this course, because it's all about experimentation. And as you develop your confidence and what you think works well for you in terms of your style, your litigation style, you'll grow into that and you will progress. So the key to doing well in this course is actually progressing. It's the progressive path that we're looking for. So don't get overly concerned about the weekly assessments. Yes, we're going to give you weekly assessments in a general sense. And yeah, they do kind of add to the ultimate mix of your final evaluation. Don't be obsessed with that, because right out the gate, you're not going to know what you're doing. You're going to be fairly uncomfortable doing it. You're going to make tons of mistakes, and you're going to feel like, boy, this is really hard, and I didn't do very well. Don't obsess over that, because you will, I guarantee you, make progress from week to week if you listen, if you do the readings, etc., and you make the necessary adjustments. So my point is, don't even think about grades during your early part of your performances. That's irrelevant. Okay? And some of you will surprise yourself from where you start and where you finish. and you will surprise us. That's the best part of this course. You know, we look at the end, from this caterpillar to this butterfly, and it's like, wow. You know, they really did pick it up, and they are effective advocates. In fact, some are so effective that I hope never to see them in court myself, because they're darn good. And we expect the same of you. So, the course in trial practice is an integrative analysis, or integrated exercise, right? So how are you going to learn these core competencies? It's going to be a combination of the readings from week to week, the lectures and or demonstrations that Professor Ciolino and I will give to you on Wednesdays, observation of your peer performances. Watching your colleagues go through the exercise is invaluable. So even if you're not actually up there, you're going to gain tremendous vicarious benefit from watching your colleagues. And you're going to pick up styles and techniques and methods that you could adapt or adopt as your own, right? And then finally, your own experience during the performance sessions. That's where you're going to grow from week to week. So let me get back to this notion of no one way. There is no one way to do this. It's an art, or more of an art than a science. There is a scientific component in terms of knowing the rows of evidence and knowing the, the basic rudimentary requirements of arguing a case before a judge. But in terms of the how-to, you're going to get different perspectives. You're going to get sometimes contrasting and inconsistent perspectives. Professor Ciolino and I may, from time to time say, well, I prefer this way because of such and such. That kind of give and take and back and forth is actually healthy. So the readings, the lectures, the instructor comments, even from these very esteemed litigants that are going to be working with you each week, they will frequently disagree about various aspects of advocacy. I'm telling you that right now. And as annoying as that may seem to you right now, it's actually a healthy reflection of the creativity and the flexibility involved in effective trial advocacy and the differences in techniques that are appropriate for different cases. You may do a direct examination differently for one witness than you would another in the same case, or from one case to the next. So that flexibility, that creativity, that is the art of the process. And so that means that when you are performing, we actually encourage you to use and choose the methods and the techniques that are best suited to meet your client's needs. Right? And that may vary. So I guess the ultimate advice is take everything we say with somewhat of a grain of salt, but there is also value in what these varying voices will say to you from time to time. You are in a very good position to learn from some very, very capable people. Okay, so I encourage you to make the most of it and do your part each week in terms of preparation, and I think you'll find it to be one of the most rewarding law school experiences that you have while you're here. So with that said, have I missed anything, Dane, in terms of logistics or administration?
No, and we're going to, one of the things we're doing is we're talking in front of this camera because our adjunct instructors aren't here for the lectures, so they're going to be watching what is said here usually on Wednesday nights, because they want to be on the same page as all of us. So that's why I'm kind of standing here. Is it getting me right now?
Yeah, you're good.
Yeah, I guess the only other thing I would add is that when the adjuncts come in here roughly in an hour or so, we're going to talk about a few more logistics and about, for example, where we're going to be posting information. Most of you have probably already found the website that went live yesterday for materials and the videos. And so there'll be a few more details we'll talk about in just a few minutes.
Yeah. I also wanted to point out that we are very fortunate to have our new director of the Trial Advocacy Center, Nicole Montanay,
Hello.
who is a
Welcome.
Loyola graduate, and she is yet another resource for you. So we're very pleased to have her and very fortunate.
All right.
All right, here you go, Dave.
Okay, so am I on the camera right now? I don't,
Yeah, you might want to scoot a little bit. Yeah, you're good there.
that's good?
Yeah, you're
All
good.
right. All right, what I'm going to talk about now is what the slide says, which is Public Speaking 101. Some of you may have heard a version of this back during Lawyering 2 a year or two ago. I've given it at various different times. So those of you who have heard this before are asking, why do I need to hear this again? Well, I'll tell you why. Because you can always think about improving your public speaking. Always. I'm constantly trying to improve mine, and these are kind of just a few basic tips. Now, I know this isn't technically a public speaking class, but it is. You're going to be standing up on your feet every Monday. Every Monday, except for when it's like a virtual Monday that we have on a Tuesday. You're going to be up on your feet doing opening statements and closings and direct exams and cross exams. So you need to be thinking about how you can develop your public speaking. So that's what I'm going to talk about. In this first lecture, I'm going to talk about Public Speaking 101, and then we'll go from there and talk about Advocacy and Persuasion 101. All right, one of the things that people will often tell you about how you can improve your public speaking is just to be natural. But the problem with being natural, if you are a public speaker, is there's nothing more unnatural looking than a public speaker who's talking naturally. So the paradox is, in order to be a natural looking public speaker, you have to talk unnaturally. That's the paradox. For example, if I were up here and talk to you like I would talk to Blaine, I wouldn't be talking the way I'm talking. I'd be talking like, yeah, hey Blaine, what kind of, can you get some coffee? God, I wish I would have gotten myself some coffee before I got here, and you brought the book, so, you know, that's good. This is not a very good public speaking voice. If I went home to my family and I sat around the dinner table and I started saying, how was everybody's day today? How was your day? Did you have a good day today? I would be annoying, wouldn't I? The voice I'm using here is not the voice I use at the dinner table. It's not the voice that I use talking to people like a human being. This is my public speaking voice. So you have to realize that just being yourself is not good enough, because you have to talk loudly. You have to enunciate your words differently. You have to take on a different persona when you're publicly speaking. But at the same time, you don't want it to look stilted or unnatural. So that's the paradox of naturalness. Another thing about this is there's nothing natural about having a bunch of eyes staring at you. From an evolutionary standpoint, when our forefathers were in this situation, it didn't turn out well for them. Which means that usually, and you all have felt it before and don't deny it. In fact, I did a poll and most of you have completed the poll. Some of you put 10s, like being 10s on public speaking. That's great. I mean, I still put myself at about an 8. Many of you put 1. That is, you hate public speaking. Well, so we've got a range of people, range of comfort with public speaking here. But one thing that we all share, I presume, is that there is some nervousness involved with it. When you stand up in front of people and all these eyes are looking at you, you get nervous. Your heart starts pumping. Adrenaline starts going through your system. And one of the problems with that is that time passes at a different rate for you than for the rest of us. Now, time is not really passing differently, but just your perception of time is different. And we've all heard the stories of how just before the truck slammed into the car, everything stood still and the person saw her life pass before her eyes. Well, I don't know if that's true or not, but it is true that perceptions of time differ because, I guess from an evolutionary standpoint, when the tiger was chasing us, we wanted to be able to slow down our thought processes to be able to decide whether to jump up this tree or that tree to grab that branch or that one. So it makes perfect sense that things would slow down and our thinking would be more clear, perhaps. But what it does for public speakers is this. It makes you feel like there are long pauses while you're talking. And it makes you feel uncomfortable. You're not comfortable with silence. You think that you look stupid. Well, I gotta talk, and if I pause too much, I'm going to look like I don't know what I'm talking about. So the tendency is to talk very fast and not to have any silence in between your words because you are nervous and you're talking fast, and that's not where you need to be. So you need to know about the adrenaline time warp, that little bit of silence wasn't really awkward. Silence is your friend when it comes to public speaking. It's nothing to be afraid of. Now, if you're going to come up here and you're going to just clam up for 30 seconds, maybe then. But generally, that little pause isn't as bad looking as you think it is. So don't try to fill it in. Okay. All right, well, those kind of prefatory remarks, let's talk about public speaking by talking about your body. Kind of an odd thing to talk about your body since we're talking about speaking. But your body really does... Oh,
sorry.
Yeah, that's all right. It's important. Body language is important because it communicates a lot. I don't know what happened to this woman. It's just a picture, I guess. But something bad happened. And she's communicating that she is not very comfortable, that she is in a bad way. In contrast, the guy over here is very confident, and he is projecting that confidence by just the way he holds his body. So body language matters. So let's talk about you and your body language in your public speaking. All right, and let's do this kind of working from the bottom up, from your feet on up. Well, why would we work from the feet up? Well, because of Newton. What's Newton's second law of motion?
Motion stays in motion.
And the converse of that?
At rest stays at
A
rest.
body at rest stays at rest. So if you start out by keeping your feet still, you'll tend to keep them still. Now, why do you want to keep them still? Well, because you don't want to be doing this. Like when you're up at the podium asking questions, you don't want to be fidgeting it around. And well, let me ask you this question, Ms. Witness. Did you see the light color? Did you see you did see the light color? We tend to fidget when we're nervous. But if you keep your feet still, you are really much more persuasive. I'm going to keep my feet still. Did you see the light before the accident?
Yes.
What color was it?
Green.
Again, I didn't do anything differently other than just stay still. If you stay still, you look more like Superman than the person on the other end of the spectrum. You just look more confident and more persuasive. So, start with your feet still, and you'll tend to keep them still. Now, I'm not telling you not to move. Am I still on the screen?
Yes.
Yes.
Yeah, it's okay to move, but move for a purpose. Like if you're moving from one point to the next. Now that we've talked about the light color, let me ask you a few questions about the weather, all right? Well, I've moved for a reason. I didn't move just to kind of keep myself occupied while I'm up here. I moved because I was moving on from one point to the other. So don't take this Newtonian physics example as my admonition to you never to move. It's to move with a purpose. Okay, now working up from your feet up to your mid-body, you need to kind of have an athletic stance. Don't lock your knees out and stand at attention. Just kind of be relaxed. And some people say be like an infielder getting ready to catch a ball, a grounder. I don't know about that. We're not going to get any grounders here. But just kind of keep relaxed. Breathe. Now, generally, your parasympathetic nervous system takes care of this just fine. So, I don't have to tell you this, but take a deep breath when you get up. It's calming. And breathing matters. The Navy SEALs do these box breathing exercises in order to kind of calm themselves down. And of course, there's all this mindfulness stuff out there now that everybody's supposed to be doing, where it's all about breathing. Breathing matters. It'll calm you down, so take that deep breath. Hands. This is one of the biggest questions that I always get. What do I do with my hands? And we spend, as trial advocacy teachers, so much of our time telling you what not to do with your hands. We're telling you not to fig leaf. We're telling you not to stand at parade dress. We're telling you not to click your pen. Don't ever click your pen around me. Please don't ever click your pen. Don't point your pen at people. We're telling you, don't. So what do you do with your hands? Well, your hands should be in this area that we would call the box, which is right here in front of you. It's smaller than a batter's box, to continue the baseball analogies, but it's basically right here. And this is the only thing that you need to do with your hands, is get them into the box. Pretty simple. See, I just put them in there. They're in the box. That's it. Now, I could tell you to do all sorts of other things, like to use gestures, but your hands know how to do that already. When you're talking to people in real life, you're not saying, oh, I need to get my hands into the box and I need to use appropriate gestures. Your hands know how to do that. They've been doing it your whole lives, all of you. And apparently, and I don't know if it's true or not, but it helps my point, so it doesn't matter if it's true. Your hands are linked to the same part of your brain that controls speech. Again, I don't know if that's true, but the point is that you are a better speaker if you use your hands. You look more natural when you're using your hands. So get them up into the box. Now, in the books on this topic, they talk about the different types of gestures, like there's the chop, there's the give, there's the show. But you know how to do that. I'm not going to say, for example, would you tell them what color the light was? That's goofy, isn't it? I wouldn't say, now tell the jury what color the light was. It just doesn't work. I would say, how far away from the light were you? Or I would say, would you tell the jury what color the light was? Or I'd say, the light at first was red and then it turned to green, correct? You see, your body knows what to do. Just get your hands. Now, why do I even need to tell you to put your hands in the box? I'll tell you. Because some of you will hold them behind your, or you'll hold on to the podium like this. Or you'll put them in your pockets. And if they're in your pockets, they can't really do, I mean, you can't really do any gesturing when they're in there. If they're at parade rest, you can't gesture. So the suggestion is just get them in the box, and they'll do their work. Your head, just don't look down. Just keep your head up. I'm not telling you to keep it up high like this because you look a little arrogant if the chin's up too high. Just look at people and get your head up. And of course, your eyes. Your mother tells you to look everybody in the eye, and it's true. So look at everybody in the eye. Now, you can't look at everybody in the eye, but you can look around the room and show people that you're not ignoring them. Now, on the one hand, you don't want to kind of lock eyes and be creepy, right? This is just uncomfortable, creepy, isn't it? Ugh. And at the same time, you don't want to be darting around the room like you're looking like somebody's going to attack you either. You don't want to do that. So you just kind of want to make eye contact periodically. One more. Okay, your voice. Now finally, we're talking about speaking. We're talking about public speaking, and now we're going to talk about speaking. What you want to aim for is structured improvisation when you're standing up, whether it's an opening statement or closing, any witness examination, argument before an appellate court, or even a motion hearing before, whatever. You want structured improvisation. You don't want either end of the spectrum. Now, on the one end of the spectrum would be uber structured, would be writing out a script for your opening, closing witness exam, and then reading it to people. And the light turned red as he approached the intersection. Well, you're gonna say every word that you planned on saying, damn it. But nobody wants to be read to. I mean, I loved it when I was 4. It was great when Mom would read to me. But I don't want to be read to anymore. If somebody's reading to me, I feel like I want to just go up and say, hey, give that to me. I can read it to myself faster than this. I get impatient. You don't want that. You don't want to be reading your questions off a piece of paper or your argument. That's too much structure. But on the other end of the spectrum, it would be uber improvisation. That's annoying too. Suppose I came here and said, okay, we're going to talk about public speaking, we're going to talk about feet, we're going to talk about hands and heads. What else you want to talk about, Blaine? Well, we're going to talk about other things. Like stuff. I mean, I got no structure here. You don't want that either. So what you want is both structure and improv. What you want is to know what you're going to say and the order you're going to say it. But when it comes to choosing the words, you're going to do that on the fly. So, for example, and this is the best advice I ever got in trial ad. I don't remember when I got it and who gave it to me, but here it is. Write out your answers that you want from the witness, not the questions. So if I want the witness to tell me that the light was red and that it was raining, all I'll write down on my outline is red light, raining. I don't write down on my outline, what color was the light, question mark. What was the weather like at the time of the accident, question mark. Why? Because I might read it if I put it in a readable format. But by writing out the answers, I'll look down and say, what color was the light just before the accident? Was it raining or was it sunny? So I've got some structure, but I'm going to improv the words. A good way to do this by way of witness exams and outlines or mind maps. I mean, I know a number of you were in my classes last semester or the year before, and you've heard me talk about these before, so I'm not going to elaborate on this. But all this is a hierarchical, categorical way of organizing information. It's just an outline in visual format. But this, I think, is the ideal way to have structure and improvisation. And this is what I use anytime I'm going to do an oral argument, anytime I'm going to do a witness exam. All I do is I step up to the podium with this, and I'll ask my questions off of that, and have all my record sites, all my deposition pages, all my exhibit numbers, all right there on that. And it forces improvisation and it forces structure. So again, that's just an idea. There are other ways to do it. You want to. The spoken word is different from the written word, obviously. We don't speak in chapters, paragraphs, sentences. We don't use semicolons, dashes, M dashes, N dashes. We don't use any of that sort of thing. So how do we structure the spoken word to make it logical and understandable? Well, we do it by chunks. We speak in phrases, in chunks, not in sentences, not in paragraphs, but in chunks. Now, a couple of things should come to mind when I'm talking about that is you need the silence. That's the steak knife that cuts the narrative into chunks. Silence. Otherwise, it would all just be one run-on rant. Silence is your friend here again. So you want to talk in chunks. And there is I don't know if this is going to play or not. And as this drawing says, your only goal while speaking is to hear the silence between the phrases. And a classic example of this is, and I know I used this last time you all heard it, everybody know what they're doing up there? It looks like they're doing Sieg Heil, right? As it turns out, and I didn't know this before I started giving this speech, that the Pledge of Allegiance originally came with a salute to the American flag. But that was like in the early 30s, and by the late 30s, that salute had been taken. So we stopped using it. You don't see this in kindergartens around America. But what you do see, and you do hear, are kindergartners talking in chunks. I pledge allegiance to the flag of the United States of America and to the republic, and you know the rest, but that's the point, is that it is not written in paragraphs and sub-chapters, it's written in chunks. Now, a great example of this, try to press you might have to move the little mouse on top, try to press this.
Good morning, I'm Adam Rumaker.
Let's see if you turn the volume up.
The Executive Director of the American Foundation for Equal Rights. It's my great privilege to be here this morning with the plaintiffs' legal team and founding board members of the American Foundation for Equal Rights. Speaking first will be David Boyes.
Now, this was a lawyer I worked for when I was a young associate in New York, and I saw him doing this and I saved it because he was talking in chunks.
10 years ago today, the United States Supreme Court, in Lawrence against Texas, took the first important step to guarantee that all Americans, regardless of sexual orientation, were equal citizens under the law. Today,
You get the point. He's just out there talking in chunks. Okay. Eliminate thinking noises. You know them. The ums and the ahs and the you knows and why, you know. You do that because mostly you don't, you don't want to have silence in between your words. You're worried, you're going to look stupid by having even a little second in between. So you tend to, while you're trying to think of what you're going to say next, you tend to, just try to eliminate those. Some people, and again, this is a classic example of what Professor Lassen was saying earlier. There are some books on public speaking that say, don't try to rid those from your public speaking voice because it makes you look more natural to talk with the ums and the ahs. Well, again, that's what some people say. I disagree. I think you ought to take them out. Take, for example, this accomplished public speaker.
We need to visit about and rehash and define and clarify. And we suggested that that's not going to play any part in this game.
Now, this is a guy who is a public speaker for a living. At least he used to be. Where does he work now? Anybody know where he Kansas. Presumably, he goes around Kansas and he talks to alums and to boosters and to football recruits and to football players and to students and administrators. And this is what he does for a living. And he eats grass. He does eat grass. Eliminate those thinking noises if you can. Use your voice to emphasize and de-emphasize points. Remember that in the written word, you might use bolding, you might use italics or underlining. Maybe if you were nuts, you'd use different color fonts and font sizes. But that's the way you do it. How do you emphasize things that you want to emphasize or de-emphasize in the spoken word? Well, by using the whole range of your voice. And remember, I'm not a musician, so I don't know the terms, but sometimes you can talk very quickly, increase the tempo of your speech, Other times, you might want to slow it down. For example, if you're doing a car crash case, if you're representing the plaintiff and you're talking about how the truck came out of nowhere, you could say, she was carefully backing her car out of the driveway, and then she looked to the left, and before she could say anything, the defendant's car just came and slammed right into the side. Well, look what I've done. I've kind of used slow, deliberate language as she's backing up. And then as we've described the defendant's car, I've sped things along. So what is the takeaway? Well, the takeaway is that the defendant's car was going very quickly just because of the tempo of my voice. If you really want to get people to listen, just lower the volume a little bit. I mean, you can hear me back there, can't you? I mean, you're way in the back, and I'm not talking very loudly, but I could really emphasize something that way. But there are other times where you really want to talk loudly. You might want to sometimes talk in a low voice, and other times talk in a higher pitched voice. And again, there may be other things other than volume, pitch, whatever the musicians talk about. But you know the point. Use the range of your voice to emphasize things. And you can really change the denotation, the takeaway, the connotation actually is the takeaway of words that are the same. Mary had a little lamb. 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 Now, again, all the same thing. I said the same thing over and over again. But the takeaway is completely different, really. Sometimes you're thinking, wow, I have a little tiny thing that she had, a little tiny little lamb she had. Otherwise you think it was Mary's lamb. It wasn't Tom's, it was Mary's. So, and here is just some examples of the way that you might step down to end. And for all of those reasons, ladies and gentlemen, you should acquit. Well, you know I'm done because that's boom, 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 boom. You might walk up the ladder, and as the truck approached her, it slammed into the side of her car. And we all know the question. The light was red.
Yes.
Now, this is something that Professor Lassen and I talk about all the time. On cross-exam, we're always telling people, use leading questions. And the classic leading question is, isn't it true the light was red? Isn't it true?
Yes.
You could ask the same question by just saying, the light was red,
Yes.
and the other car was speeding.
Yes.
Now, I'm not going, isn't it true? Isn't it in fact that? Just raising the voice at the end to turn a declaratory statement into a question. All right, so how can you improve your public speaking voice? Well, for starters, you can get this book, The Articulate Advocate. If you were to get that book, you would see that my entire speech today has been ripped out of this book. This is a complete rip-off. I'm just telling you, I got to be honest with you. I've had a couple of original thoughts today, but not many. But not many. This book is great. It's on Amazon. It's like $10. I don't make any money off of the book. Just go to Amazon and Google it and buy the book. There's a lot more in the book. I mean, right now we're running through. I'm almost out of time. There's a lot more in the book. For example, he suggests things like, taste every consonant. And, I'm not tasting every consonant in front of you right now because I don't want to spit on everybody. But, again, there's a lot more in the book. And he talks a lot about how you should practice your public speaking. I remember when I heard him speak, Brian Johnson. I heard him speak down in the moot court room, the moot court trial room. When I was running a seminar, we hired the guy. We paid him $5,000 to come to speak to this group, the Louisiana Association of Defense Counsel. And I was sitting way in the back, and I had my laptop, and I was like, oh, here goes another speaker. I'm just gonna answer my email. And this guy started talking, and I closed my laptop, probably the first and last time I ever did that. And I listened to him for an hour, And it was great. And after he was done, all I could think is, I'm gonna rip that off. And that's what I've done. I bought the book and I ripped it off. So what you ought to do is get the book. And there's lots of stuff in there about how you can practice this. Like he said, when you're driving around, you can practice talking to yourself. And you know, back 15 years ago, you really looked nuts. That was before Bluetooth and everything. Now people just think you're talking on a very important conference call. And you can be practicing your enunciation and these sorts of things. After that speech that I heard in August, I then used the whole year. I was teaching all the same classes I always teach. I was like, well, I'm going to use evidence this year to practice my public speaking. And I'd go in there and spit all over everybody in the front row by practicing different things. I would be talking about hearsay and whisper sometimes. Hearsay is an exception. And, you know, but it gave me an opportunity to practice. So you need to take this semester as an opportunity to practice. I'd buy the book if I were you. It's a quick read. And I would think about all the things that Ryan Johnson and Marcia Hunter suggest. They also got a YouTube channel where he demonstrates a lot of this stuff. And that's a good place to start. But at the end of the day, you just have to practice. You just have to practice and practice. All right, does anybody have any questions about public speaking? Okay. Now I'm going to talk about rhetoric and advocacy still. What time are the adjuncts coming?
They should be up momentarily, but I'd say at least 10 minutes.
Okay. Let's switch to the next presentation on the slide, wait. Close all that out. And then go back to the Kingston D, the persuasion right there. Yep, persuasion. And click on Persuasion 101 and hit play.
There's a thing at the bottom, right?
Yep. Okay. This one isn't ripped off. I did this one all by myself. But this is the problem. This is like a 45-minute speech, and I got like 10 minutes maybe. So I'm going to start talking about this, and then when I run out of time, well, I'm running out of time. All right, so here we go. Rhetoric. Rhetoric is just the art of persuasion. And all of rhetoric, really, and this is true, this is kind of amazing, but rhetoric, nothing very little new in the art of rhetoric, the art of persuasion, has been said since the 4th century BC, when Aristotle wrote his book. Well, it was up there. That's all right. The art of rhetoric. So what I'm going to talk about, these basic principles of persuasion, and these are basic principles that you need to bake into your direct exams, your closing arguments, your cross exams. What I'm talking about here with regard to these basic principles are what should guide you in the substance of everything that you do as a trial lawyer. All right. First of all, logos.
It went across.
Oh, it already went across. Okay. I want to see it go across again. Logic. To be persuasive, your argument has got to be logical. To be persuasive, your argument has to have pathos, as Aristotle called it, or emotional appeal. You need to appeal not just to brains, you need to appeal to hearts. And then finally, any good argument is going to have ethos, personal advocacy. You have to as Professor Lassen said earlier, you have to be a believable, trustworthy, and knowledgeable lawyer. Because people are going to be looking at you, and you need to project that you know what you're talking about, that you're prepared, and that you are not trying to lie to them. So those, according to Aristotle, are the 3 stool legs of persuasive argument. Ethos, pathos, and logos. Now, that is Herbert Stern, and those are Herbert Stern's books. Book series called Trying Cases to Win. I got that 5-book set when I was a young lawyer in the 90s, and I read it, and then it came out with videotapes, and I watched all those videotapes, and I became quite a Herb Stern disciple. And oddly enough, when Professor Lassen and I started teaching this course together, he said he was a Herb Stern disciple. We almost embraced. Just warms the heart to know
It was a beautiful
that
moment.
two people on this earth had found Herb Stern, independently of one another. Herb Stern himself is just a disciple of Aristotle. He's got the 4-volume book on advocacy, and what I'm going to do, here I go again, I'm going to rip off Herb Stern. Rule 1, according to Herb Stern, is personal advocacy. Use personal advocacy. He said, because Aristotle said it 4 centuries before him, that the most persuasive thing about an argument is not its logic, is not its emotional appeal, but it's the speaker. It's the ethos. And that's not the way it's supposed to be. In a perfect world, the finder of fact would use only logos, would only weigh the law on the evidence. But Aristotle knew it, and Herb Stern knew it. Your credibility is critical. So you've got to use personal advocacy. That's rule 1 in his book, and in Aristotle's. Why is it so important? Well, because these jurors, or if it's a judge, the judge, they're looking at you, okay, and they're thinking,
Oh.
that you know the truth. Now, sometimes we do know the truth as lawyers. Sometimes we don't. Often we don't care. But there is that truth. And the jurors think you know it. And they also are looking at you and deciding whether you're trying to deceive them. If they want you, they think that you want them to learn the truth, that's good. So being a good personal advocate and having lots of ethos means projecting both of those things. That you know what you're talking about, and that's because you've done your homework. And that you're not trying to lie to them. You're trying to help them get to the truth. You want to do everything in the courtroom to project that. Okay, so let me see if are they out here?
Yeah, it is.
All of them are here?
I think so.
Oh yeah, they are.
Yeah, we probably have. Let them
Just have some in the elevator, sounds like they're coming though, right?
Oh, okay, all right. All right, well, we're not going to talk about this anymore. We are going to talk about it on another day, perhaps.
Dave, what would you like, you stand up here?
Yeah, everybody can come.
Oh, we're not using PowerPoint? I want I just saw Nicole, they must be coming in right this way.
Hi guys. Hello. So happy to see so many great friendly faces. I am just here to let you know that the Advocacy Center is fully behind this change in the program to really make this trial advocacy experience much more meaningful to you. And so we have this distinguished panel of adjuncts that you will be meeting right now and you will be getting to know over the semester. So I'm going to have them introduce themselves so you get to know a little bit, and you'll find out on Wednesday what section you will be in. So we'll go ahead and start with Judge Pittman.
All right, well, good evening. I'm Judge Robin Pittman. I'm a judge at Criminal District Court. I am a double Loyola alum, graduated from the undergrad as well as law school, and I don't know what else I'm supposed to say, but I'm excited.
Now she's going to bring a kind of a criminal court judge's perspective to this.
Yes.
And our not that there really should be much of a difference between a good criminal lawyer and a good civil lawyer, but it'll be interesting to hear people's thoughts on this as we go. So that I think is Judge Pittman's unique perspective.
And I'm in the middle of a trial right now, if you want to come and sit in tomorrow morning.
All right.
My name is Jo Heller, and I graduated from Loyola Law School, and I actually had Professor Lassen and Professor Ciolino as law professors. Y'all made me nervous then, and I'm starting to feel it back, so please don't call on me. Just kidding. I am currently an assistant DA in St. Bernard Parish. Prior to that, I was an assistant DA in St. Tammany Parish, where I was head of the Domestic Violence Division. I was also an assistant DA up in Monroe, Louisiana. I've tried a bunch of cases. I was a defense attorney at a law firm in Baton Rouge, so I've been on both sides, defended, prosecuted, have argued before pretty much all of the state appellate courts throughout Louisiana. I'm really excited to be here, and I look forward to meeting y'all and having fun this semester.
Hello everyone, I'm Don McKinney. I'm a partner here at Adams & Reese in New Orleans. I've been here about 20 years and practiced in Little Rock for about 6 years before that. I have a kind of a general civil defense practice, which has involved for many years a bunch of medical malpractice defense, and that, as you may know, turns out to be the cases that tend to get tried a lot in the civil arena in Louisiana. So most of my trials have been malpractice trials, although I've done other things as well. I've never taught trial ad before. I've always wanted to, and so I was happy to be asked to do it. And I'm expecting to learn a bunch as we go, because you'll find out when you get out that, you know, there's things you learn in law school that you don't keep fresh. And so I'm looking to get fresh and to help you guys learn a little bit about trial practice. Really looking forward to it.
Okay. I'm Ellen Shara Kovach. I'm a graduate of Loyola. In fact, Rose, Judge Leday and I were classmates at Loyola Law School. Practiced law, general litigation, primarily in federal court for about 20 years before becoming a judge on the 24th Judicial District Court about 10 years ago. In Jefferson Parish, we do have a criminal and a civil docket, and I do encourage you all to come and watch. As Judge Pittman said, there's no better experience than observing trials other than doing trial work yourself, and that's what we're going to be doing. We're going to be learning to try cases by doing it, and that's, I think, is the best way to learn. I am going to be teamed up with Mr. Litchfield, who is a prominent downtown lawyer. I have taught trial ad at Tulane and Loyola the last few years, Tulane for the past 10 years. I love watching you all develop and grow. There are lots of reasons to take trial ad, not just if you're going to be a litigator, but the skills that you learn in this course are going to serve you no matter what you do. So I'll look forward to working with everybody.
Hi, I'm Rose Leday. As Judge Kovach said, we were graduates of the law school. I served for 12 years on the Civil District Court bench, which is the trial bench here in New Orleans, and I'm currently in my 8th year on the appellate court here. I've presided over numerous trials. I started my career in Mr. Litchfield's firm. He used to be my boss.
That didn't last long.
And I'm looking forward. This is my first year teaching trial ad, so we're going to be in this process together, and I'm looking forward to it. And hopefully we can all learn together. Thanks.
And I'm John Litchfield, and I'm just a practitioner. But I've been doing it for about over 40 years, 40-something years downtown. And I went to the other law school uptown. But that one, again, was a long time ago. So I'm looking forward to working with Judge Kovach and helping him in any way I can and learning myself. And Judge Leday's right, she worked for me, but she was actually my boss when she worked for me. So.
Don't believe it.
Hello, I'm Paige Sensenbrenner. I graduated from Loyola Law School in 1987. Since then, I've been practicing with Adams & Reese downtown and now serve as senior partner in charge of the office. In fact, I started off doing litigation, cut my teeth doing medical malpractice cases, and then that evolved to where a good portion of my career has involved the defense of medical device and pharmaceutical companies and product liability actions and claims brought by the Attorney General. And then I've also done a fair amount of toxic tort defense and some commercial litigation as well. So.
All right, well, thank you all for coming. So this is the way that the drill is going to work. Now, Professor Lucen already talked a little bit about this, but the way it works, of course, is that on Wednesdays, Professor Lucen and I are going to, I'm sorry, I'm standing in front of you. Professor Lucen and I are going to do the lectures. We're going to record them so you can, for example, if you've got opening statements to do on Monday, on the Wednesday before, we're going to lecture about it. You should come to the lecture having read the material in the Maue book about what an opening statement's all about, and then come and listen to our take on it. And then we're going to record it. We'll post the video on the website. Everybody should have had access to the website. And that way our instructors, adjunct professors, will be able to see what we told you all. Since they're not going to come on Wednesdays, they'll be able to see what we told you all about our thoughts on opening statement. And then on Monday, you're going to come do opening statements, for example. And one thing Professor Lucen said could not have been more true. You're going to hear something from me or from Professor Lucen about the best way to do an opening statement or a direct exam. And then one of these practitioners or judges is going to say, you know, I don't like that. I like this. And you know what's going to happen? Somebody's going to send a nasty email to me like, well, we're getting mixed messages here. Well, what's going to happen? You're going to get mixed messages. Who's right? Well, who knows? Who knows? It depends on all sorts of things. For some people, you might have the personality to do it this way, but not that way. So this is art, not science, really. So the reason why I'm saying this in front of everyone is because one of you might tell Mr. Litchfield, oh, well, that's not what Cialino told us. That's not what the book told us. And now you're telling us this? Yeah, get used to it. Get used to it. And just kind of think about it and analyze what might work for you and whether you disagree with us. That's just the nature of the way this works. Okay, so that's the way that Wednesdays and Mondays will work. We're going to, on Wednesday, tell you which group you're going to be in. We're going to have 5 sections, right?
5 sections.
We're going to have 5 sections. Each section will have between 8 and 10 people in the section. And you will come, and as Professor Lucen said, you will play the witness for a while. You'll play the lawyer for a while. Different sections may be doing this different ways. Some sections may want you to go very briefly and then give you critiques. Other sections may have you go for 10 minutes and then critique you, make you do it again. Again, we're not micromanaging the way that the different sections are running, and we'll have little experiments going on in all of them. But you need to come on Mondays prepared, and that's the biggest thing, because there's no way to wing this. If you haven't come prepared,